you very much for joining us. I'm Gary Lermer, PACE's Vice President of Development and Alumni Relations and a 1980 alum of the Dyson College. So to all my Dyson friends out there, hello, and everybody else too. It's hard to believe it's been almost a year now, going back to last spring, that we began a series of virtual events to engage, educate, and continue to be friends with our PACE alumni population. In the last year, we've had over 3,500 alumni participate in all of our events, and the response continues to be quite overwhelming. There are 133 of us so far on this call already today. If you'd asked me, we could have ever gotten 133 people to talk about estate planning, I probably would have said no, but I'm glad that you all have proven me wrong. Thank you. Today is our topic is estate planning, and it will cover a number of basics around estate planning and legacy building. We'll talk about the importance of how you are covering all of your wishes in your estate plan. And to those of you who have expressed your wishes through your estate plan to include PACE University, we thank you very, very much. We appreciate it deeply. The students who will benefit from your largesse, although they won't be able to thank you personally, please know what a significant difference it makes in the life of our students and the life of the university. For those of you who have already told us about your plans and are a member of our Edward J. Mortola Heritage Society, I give you a very special welcome and glad you can be with us today. I hope we'll be able to answer all of your questions. We'll follow up with an email if we don't get to everything, but we do ask everybody to keep your Zoom on mute so that we can all hear each other through the program, and that you'll be able to submit your questions through the little chat button on your screen. It's now my pleasure to introduce our moderator for today's event, dear friend and a great dean, the Dean of PACE's Elizabeth Howe Law School, Horace Anderson. Dean Anderson is an attorney, admitted to practice in 1997, and began and joined our faculty back in 2004. The Dean also teaches courses in intellectual property, contract law, and data privacy, and is joined us as Dean of the Law School just about a year ago in January 2020. Please join me in welcoming Dean Horace Anderson. Horace?
Hello, everyone. Thank you, Gary, for that kind introduction. As Gary said, I took over as Dean just in time about a year ago. We've had quite a year, but I'm very happy that you're all here joining us for this panel discussion, our second Estate Planning 101 session. I'm delighted to welcome as our guests two experts in estate planning, Anne-Marie Rezzonico and Anthony Enea. And they've got many years of experience and will be able to share a lot of that with us today. Anthony is the managing member of Enea, Scanlon, and Sirignano, with offices in Westchester County, New York, devoting his practice to educating and protecting seniors, the disabled, and their families from the costs of long-term care, including elder law, estate planning, asset protection planning, special needs planning, Medicaid applications for nursing home and home care, and guardianships. Anthony has been named a super lawyer, a best lawyer in America, and a lawyer of the year by numerous legal professional organizations. Anthony received his JD from PACE's Howe School of Law in 1985, and in 2018 received our Distinguished Service Award. Anne-Marie practices estates, trusts, and real estate in Palm Beach County, Florida, as a co-founder of Rezzonico and Egan. She's an original member and a past president of the Palm Beach chapter of the Florida Association for Women Lawyers. She devotes significant time to her philanthropic passions: women, children, education, and the arts. She has held leading roles with Wilkes Honors College Advisory Board, Palm Beach Community College, now known as Palm Beach State College, Florida Easter Seals, Palm Beach County Women's Chamber of Commerce, and Palm Beach Drama Works. She received her BBA in 1971 from Pace University and her JD.
Yes, Ethel Vandecruz.
Her JD from Nova University in 1983. So as I said, very excited to have our experts here today. We're going to jump right in with some questions for them. So first question is going to be a compound one. And that is, a lot of people ask the question, why do I need estate planning? You know, my life is so simple. I don't have that much. I don't have that many assets. And if I'm going to go the estate planning route, what are the reasons for and pros and cons of using trusts as a vehicle rather than a will?
Well, good afternoon, everybody. I'm pleased to be here and hope to be able to help a little bit in your decision making. I will tell you from the very beginning, a will operates only on assets in your own name alone. So if your assets are held solely in the name of Anne Marie Rezzonico, a will is going to distribute those assets. A will does not distribute anything that's held jointly. It does not distribute anything that has a beneficiary designation on it, and it does not distribute anything in a trust. And there are multiple types of trusts, but we're going to talk right now about the difference between a will and a revocable trust. It's called revocable, revocable, living trust. Some people even call it a loving trust. And that's the trust where you set up basically a legal fiction. You establish a document of Anne Marie Rezzonico, trustee for Anne Marie Rezzonico. So it is a retitling of your assets into your own name as trustee. You can have a co-trustee. That's up to you. It depends on your ability to want to share your information with someone right now or wait until later. So a trust operates during your lifetime and after your death, where a will only operates after your death. A will also requires a court proceeding. In Florida, there are several different types of court proceedings depending on the value of your assets that are going through the proceeding. But you do need a court proceeding in Florida if you're operating with sole assets under a will. If you're operating with assets in your trust, you would be able to take your brokerage account, your bank account, your home, and transfer these assets to your name as trustee, with the understanding that your successor trustee, the person that you appoint, would take over and operate your assets either during your lifetime if you were to become incompetent, if you decided you didn't want to do this anymore and you wanted to resign, or after your death. After your death, there would be no necessity in Florida for a court proceeding if your assets are in the trust. So that's one major difference between the will and the trust. It also operates to allow your either co-trustee or successor trustee to manage your assets should during your lifetime you be incapable of doing so. Again, that prevents in Florida the need for a guardianship, which we were talking about earlier is one of the worst procedures you can have in Florida. A guardianship means that the court appoints someone, they have to file accountings, they have to meet with doctors, they have to go to school, they have to, it's not what you want to do. So, and it also could be someone appointed who would be taking care of your assets, that's somebody you don't even know. So your trust document allows you to control what happens during your lifetime and after your death. So it operates during your lifetime if you become incompetent, but it operates after your death because it would have the provisions in it that a will would normally have. It would say, pay my debts, pay my expenses, and here's who I distribute my assets to. You can distribute it to outright to people, or you can distribute it in further trust to people, and we can answer those questions after. But it does provide a huge measure of security and safety here so that you are in control of what's going on during your lifetime and after your death.
Thank you, Anne Marie. So a lot of these issues we're talking about are going to be governed by state law, and so they'll be handled slightly differently depending on what state you're in. Anthony, can you give us a New York perspective on the on wills and trusts, and on what happens when you don't have an estate plan, when you don't do estate planning?
Well, thank you, Dean. I'm very happy to be here today and to see a lot of PACE alumni. Thank you for having me. Well, if you don't have a last will and testament and you die and you don't have a trust, then what happens? The rules of intestacy govern the administration of your estate. Anyone technically can apply to become the administrator of your estate. So without having a will, you've lost the ability to nominate somebody of your own wishes to be able to handle your affairs when you pass away. So at a minimum, everybody should have a last will and testament. I agree with Anne Marie that there are many, many advantages to having a revocable living trust. The largest advantage is the avoidance of probate. The other advantage is that your affairs are private. They're not public. When you do probate, the petition for probate has to list what assets you have, who your beneficiaries are. Additionally, probate has an element to it that could be quite dangerous. The danger part comes if somebody wants to contest the will. Contesting a will is much easier than contesting a trust. So having a trust that holds your assets at your death makes it harder for individuals to contest your estate. It eliminates the possibility that your family is going to have to go through the entire probate process. So in New York, from beginning to end, the probate process can take anywhere from 9 months to 1 year. Unfortunately, for people that passed away last March, last February, last April, while the courts were closed, the probate process is taking longer. So I'll give you an example. A client of mine recently died. She was in her 90s, and she had a house that was in a revocable living trust, and she has 2 daughters that are now the trustees of the trust, and they're also the beneficiaries. All we need to do now is do a deed, transferring the house to the 2 daughters as equal tenants in common, have the 2 daughters sign receipt and releases, and we're done. The estate, the trust has been administered. You're not going through the probate process, 9 months to a year, legal fees, filing fees, potential for a contest, and more. And another element that people don't even think about is when your will is offered for probate, on the probate petition, you have to list any individual that is either a beneficiary or that could inherit if there was no will, that has a disability, a person under a disability. And in New York, that will require the court to appoint a guardian ad litem for the individual that's under a disability, further delaying the probate process, requiring a report by the attorney that's appointed as the guardian ad litem. So as you can see, probate has a lot of different moving parts, a lot of expenses, and a lot of time-consuming expenses that really slow down the process of distributing assets to the beneficiaries. Whereas if all the assets are in a trust, you have your children as the trustees, you have the children as the beneficiaries, things will move much quicker and much better.
Thank you, Anthony. That last bit that you said connects with one of the questions that we got from some registrants ahead of time. What would be the steps for establishing a trust for the protection of minor children? What are the particular issues that come up and that people should be aware of when the kids are still minors as opposed to being adult children?
Yeah, that's very important here, especially because although the rules are different for probate here than they are in New York, as Anthony discussed, the establishment of minors guardians is not different at all. So if you have a minor child, if you want to leave something to your grandchild and your grandchild is 10 years old, you absolutely do not want to leave that money directly to a grandchild because the court will step in and appoint a guardian ad litem and will start the whole court process, which was the entire point of not doing it to begin with, okay? So in your will, if you choose to just have a will, or in your trust, in the distributive provisions after your death, you are allowed to establish what's called a minor's trust for the benefit of that grandchild or your child, if your child is a minor. And you will be able to set it up so that you can provide exactly what you want in the provisions for that minor child. In our documents, we established the fact that we can purchase health insurance for a grandchild or for a minor child, let's just say minor. Because if the parents are gone, they may never have health insurance again. It's cheaper to buy a child health insurance than it is to pay for their medical emergencies. You can provide for income to take care of that child to a person who has taken the child as a guardian. You can provide educational money for that child. And it's totally up to you whether you want to provide educational money for the child from kindergarten all the way through college or just for after high school. You can provide it for graduate school. You can provide it for books and tuition. You can actually control the money that goes to a minor child. And at a certain age, the money will come out. It can come out at, we never ever recommend anything under 21. I mean, I don't care how much money it is. There's going to be a car in a driveway and a great party. So we absolutely just don't want to do that. So we would establish a trust, and at a certain age, after everything else has been met, and if there's money left in the trust, you would do a distribution to that child who is no longer a minor at whatever age you choose, and the money would come out and the trust would cease. The different question here is, what do you do with your child, your adult child, who has a problem and can't manage money, is a spendthrift, has a rocky marriage, has a drinking problem? You know, again, you can establish a trust for that minor child. What you need to understand at that point is you are not giving that, excuse me, the adult child, I apologize, the adult child. You would not be able to give that child, that adult child, his or her inheritance. You're holding that money back in a trust, and you're asking someone else to manage that money and make decisions as to whether or not they're capable to handle the money. Are they not in jail? Are they not in a rehab program? Again, you can do that. So you can manage if there's a problem for an adult child, and you can manage if there's a minor child you wish to give to.
Well, we also do, Dean, in our documents, obviously, I agree with Anne Marie, you don't want to have money going outright to an 18-year-old or a 19-year-old. Generally, most of our clients pick the ages of 25 or 30 or 35, depending on the size of their estate. So they'll have money go to their children. They know the children are financially responsible, but God forbid one of the children has predeceased them, and now money is filtering down to the grandchildren.
Mm-hmm.
They really want to keep that money in trust to a certain age. One of the provisions that we include in our documents says that notwithstanding the fact that the beneficiary has reached the age that they're entitled to the money, we give the trustees the ability to withhold the money if they believe that it would be in the best interest of the beneficiary to do so.
Mm-hmm.
And we spell out if there is a possibility of is there ongoing bankruptcy, divorce, whatever the case may be. So we allow that, notwithstanding that the age has been achieved, that the trustee can still retain the funds in trust for the individual.
Mm-hmm.
Very good. Thanks to you both. Let's talk taxes for a moment. Estate taxes will depend on the size of the estate, so they may not always apply to everyone in all cases, but it is something to keep in mind. What can you tell us about estate taxes on both the federal and state levels?
Well, at this point in Florida, we have no estate tax and we have no income tax. So that obviously is the draw for some very wealthy people to come down. But the law as it stands now is, I believe, $11,500,000 can pass tax-free from each individual. And if you have a married couple, if you set it up correctly, again, this is another whole discussion that's not part of here, but if you set it up correctly, you can pass over $22 million tax-free. But you know, that shouldn't hinder your thought process in doing your estate planning. You're going to say, I don't have $11 million and I'm never even going to win the lottery and no one's going to give me that money. It doesn't matter. The estate tax consequence to this is a different part and a different discussion than the fact that you truly need a will or a trust. And the other thing that's going on at this point is Congress is always discussing lowering that estate tax value. So no one has any idea what's going to happen with that, no matter how many seminars we go to. So, but it shouldn't stop you from having an estate plan that works for you.
I agree with that. I mean, the federal estate tax exemption for 2021 is $11.7 million a person. What you should understand about the federal rules are that the federal rules are both a estate tax and a gift tax exemption. So in addition to being used for estate taxes, during your lifetime, you could make taxable gifts of $11.7 million. As everybody knows, you can give away $15,000 per person per year without requiring the filing of a gift tax return and without utilizing any of your lifetime exemption. Additionally, you can pay the educational and medical bills of anybody so long as you make the payment directly to the educational facility or the medical provider. And you could, for example, pay the tuition of your grandchildren, your children. No limitation on that in terms of there being a gift tax. So the federal amount, 11.7, can be used during your lifetime or on your death. Husband and wife have, over $23 million. And under federal rules, there is this concept of portability. So let's say, for example, I die and I have an $11.7 million exemption, but I only have $5 million in my name when I die. My spouse can file an estate tax return for me, elect portability, and then transfer to themselves the remaining balance of my exemption. So they can basically transfer $5.7 million of the estate exemption to themselves because the federal government allows for portability. In New York, the estate tax exemption is not a gift tax exemption. It's just an estate tax. And for 2021, the exemption is $5.93 million. In New York, there is no concept of portability, right? So there is no such thing as portability. In order to use the exemption, you have to have assets in your name alone. If their assets are in joint name, then the exemption is not going to provide. So if you have a $7 million estate joint with your spouse and you die and everything goes to your spouse by operation of law, your entire 5.93 exemption has been lost. It disappears. You can't use it again. And in New York, there's something else called the estate tax cliff. If your estate is 5% greater than the amount of the exemption, so I'll give you an example. 5.93 is the exemption now. Let's say I die with a $6.4 million estate. That's 5% greater than the $5.93 million. Then my entire estate is taxable at the highest tax rate in New York, which is 16%. You've gone over the cliff. And once you go over that cliff, it's not just the amount above the exemption that's taxable, it's the entire amount of the estate, and it's taxable at the highest amount, which is about 16%. So you have to be very careful when doing planning in New York to, if your husband and wife, to divide assets between the spouses so that they each have up to the amount of the estate tax exemption. Where these exemptions are going to go in the future, we don't know. At this point, there's already bills pending since 2019 federally that reduced the estate tax exemption from the 11.7 million to 3.5 million. Whether those bills are going to go anywhere, we don't know at this point.
Thank you. So we've talked quite a bit about assets and how to protect or pass assets using the trust or will vehicles. Let's talk a little bit about other aspects of estate planning. What can you tell us about use of power of attorney documents, living wills, and healthcare proxies? How should that fit into people's planning?
In our practice, again, down here in Florida, a lot of times there are older people, their families are not here. So you want to protect yourself and your durable power of attorney, your healthcare power of attorney, and your living will are vital for your lifetime. If nothing else from this pandemic, you need to make sure that you understand that if you're not well, you need to pick someone who can make healthcare decisions for you. So a durable power of attorney appoints someone who can deal with anything other than healthcare here in Florida. This is how we do it. We break it so that it's administrative, financial, dealing with Medicare, with insurance companies, with motor vehicles, with anything. If you don't have a power of attorney, these people and these organizations will not speak to you. So if I needed somebody to call up motor vehicles to find out something and I couldn't do it, my husband, they wouldn't talk to my husband unless he can provide them with a power of attorney. So you're trying to override the HIPAA laws, the privacy laws, by establishing an agent for you who can deal with basically financial administrative dealings. You could be hospitalized. You could be out of the country. You could be somewhere where you can't be reached because there's no cell phone. So someone has to be available to do that for you, okay, during your lifetime. And a power of attorney ceases on your death, and your documents take over, your will or your trust. So that's another reason why this is all comprehensive. In a healthcare power of attorney, the way we operate in our practice, that's different from a living will. The healthcare power of attorney can operate. It does not have to be a life-ending or life-threatening decision-making process. If you fall down and break your hip and somebody needs to talk to a hospital or a doctor or a nurse or a pharmacy, you can appoint whoever you need to operate for you to make healthcare decisions for you. And you would also, in our documents, you would appoint an alternate for that, so that there's always someone, as opposed to a court or someone else making a decision for you, that you don't choose to make that decision. So that's the important thing that you have to do here. A living will operates basically as a die with dignity statement. It says, do not resuscitate me, do not force feed me, do not do whatever has to be done based upon your wishes at the time of your death. You could be in a coma, you could be incompetent. There's lots of ways to do all this, and it's situational. So it's hard to make just a blanket statement about that. But in our practice, we use two different documents because although the healthcare document, power of attorney, can be used for life-ending or life-threatening, it's more important to have somebody there who can operate when it's not the end-of-life decision. We also have changed our documents to include language regarding COVID. Your healthcare documents basically say, don't resuscitate me. And we have put in language that says, unless it is a COVID-related necessity or a virus that is similar to the COVID, my healthcare agent can overrule this decision about resuscitation or whatever else needs to be done for medication. It's important to be, for us here, especially in Florida, we recommend every 3 to 4 years that you look at these documents, especially the healthcare and the power of attorney and the living will, because situations change, people change, you may want to change who is in charge of you. The other important thing here in Florida, and I don't know about New York, is we're not able to execute or prepare a DNR, a do not resuscitate. That's only allowed in Florida through a doctor or a hospital situation.
We're pretty much the same on the DNR. The DNR is not prepared by the lawyers in New York.
Okay.
It's prepared by the doctor and signed by the individual. It's usually used for individuals that have chronic conditions, that are life-threatening conditions like COPD. Our healthcare proxy is a little bit different. The healthcare proxy in New York only comes into effect when the principal, the person signing it, is no longer able to make medical decisions. So if you can continue to make medical decisions, your agent is not going to be making the decisions.
Yeah, I'm
One
sorry,
thing-
I don't mean to interrupt you, Anthony, but if I left that out, I apologize. That's exactly the same here.
Okay, so you.
I'm sorry,
Yeah,
yeah.
you can't
You can't
basically.
override the person's, yeah, okay.
Exactly. The other thing in New York is you can only have one agent at a time. I see a lot of healthcare proxies where the individual appointed two agents as co-agents. That doesn't fly in New York. Only one agent at a time, very important document, where you basically tell the individual you're appointing what your wishes are about care and predict, specifically end of life decisions. You want them to know what your end of life decisions are. I think the most important document that any one of us can sign is a durable power of attorney. That's where you appoint somebody to make financial decisions and handle your financial affairs if you can no longer do so. In New York, you can draft the power of attorney as broadly as you want or as restrictive as you want. I like to draft them very broadly because I'm always concerned about the agent needing to do planning for the principal to protect assets. You know, we talked a little bit about estate taxes, and I must tell you, estate taxes only impact a very, very small part of the population. The vast majority of the population is never impacted by estate taxes. Their bigger concern is going to be the concern about the cost of long-term care. So what we always want to do is draft a power of attorney that allows the agent to transfer assets out of the name of the principal to the spouse, to other individuals, so that we can do long-term care and Medicaid planning for the individual. So the power of attorney, very important. New power of attorney form coming out on June 13. One of the biggest changes is that there's no longer going to be the statutory gifts rider attached to the power of attorney. All the gifting will be spelled out in the modification section of the power of attorney. That's the biggest change. If you want to see an article about it, I have an article that's going to be published by the New York State Bar Association, and it's right now on the homepage of the New York State Bar Association about the new power of attorney law and all the changes that go into effect.
So I've got a question about these agents, the agent or agents that one might choose for any of these documents. What advice do you give clients about how to choose that person, how to make sure that the agent is the right agent for the decisions that are going to have to be made?
Well, we give differing advice. There are family members who are very aware of their financial responsibility if they're holding a power of attorney, and they understand it's not their money they're dealing with and that they are fiduciarily responsible. So it may be someone who understands money and ability to act, to understand the tax laws, as Anthony is saying. I agree with him 100% on that. So and I'm also telling you that that person may not be the same person who can make healthcare decisions for you. You absolutely need someone who will follow the directive that's in the document that we prepare for you, and will be able to do that almost unemotionally and follow your directions, as opposed to putting their own intent and purpose in. So it's very situational as to in our practice as to what we advise. And we talk to the clients about their family members, and some people absolutely refuse to have their husband do it or their wife do it, and they want a child to do it because they know the child will follow the directions that's in the document versus a spouse. So it depends.
Yeah, individuals always look at a variety of different factors. You know, when it comes to being a trustee of a trust or the agent under a power of attorney for financial matters, we're always looking for somebody that has a certain level of financial acumen, somebody that's astute in financial matters, somebody that you have a great deal of confidence and trust in. You know, one of the things that we ask about is, you know, what kind of relationship do you have with your children? What does your child do? What kind of line of work are they in? Are they financially responsible? Are you supporting them in any way? Because that would be a critical component of deciding whether or not to appoint them to a position of great financial responsibility vis-a-vis the parent's estate.
Thank you. So Some of the questions we got from audience members are about not having anyone that they think they should be leaving or could leave assets to. They may not have any children, they may only have siblings, they may not have anybody that survives them when they go. Can you talk about other options, whether it's non-family friends or whether it's organizations that people can think about in terms of planning their estates?
Well, what we normally do is when you don't have immediate family members. So if I have no children, I'm married and it's myself and my spouse and I have no children, then the next thing we talk about is, do you have siblings? And how close are you to siblings? If you don't have siblings that are alive, do you have nieces and nephews? Do you have cousins? So we go through the line of the family, because when there is no child, we want to create something similar to a family tree. We want to be able to see who the members of the family are in case there are any issues raised later in a challenge to the will or the trust. So we go through the exercise of creating the family tree. But more importantly, we're really looking for the relationship that you have with somebody. How close is that relationship? And is this somebody that you want to inherit from you when you pass away? Many times they don't have any individuals that they want to leave it to. So now we're talking about charities. And there are issues when you appoint a charity as a beneficiary. For example, in New York, if you give a specific amount to the charity, a specific dollar amount, then you don't have to do an accounting. The executor doesn't have to do an accounting when the will is finally completed, admitted to probate, and the distribution is made. However, if you're giving a percentage to a charity, then the Attorney General of the state of New York is an interested party in the estate proceeding, and the individual that's the executor may need to do a formal accounting. So those are the kinds of little things that we counsel the clients about in terms of charities. Obviously, it's really up to the individual. We look at if they have any schools that they attended that they have a great relationship with, college, law school, etc. And we counseled them about that, because those are charitable bequests. You could leave your entire estate tax-free to charities. So that's something to consider.
Yeah, it's a little different in Florida as to accountings, and there are ways around certain accountings. That's just all state-wise, and it all depends on that. But we do talk to people about whether they are interested in some philanthropy, whether they can want to honor a family member and set up a scholarship, or deal with something like that for in their school, in their alumni, they were alumni of, or a charity that they have particularly given during their lifetime. So yeah, there are different ways to establish who can, and you can do it, you can split it. It doesn't mean if you give to family, you can't give to charity, or if you give to charity, you can't give to family. You can distribute it however you choose.
Well, that's great. Thank you so much for your answers to our questions so far. I see we have a number of questions that have come up in the chat as well, and we're going to turn to those now. Michelle Camardella of the PACE Development and Alumni Relations Office is going to take over and field some of those questions from the chat. Michelle?
Great, thank you. The first one we have here is, what constitutes, quote, disabilities in New York probate besides being a minor?
Well, in New York, the disability can be anything. It could be a physical disability. It could be a mental disability. Obviously, being a minor is a disability. But if you're a senior and you have physical disabilities, cognitive disabilities, I die and my wife has Alzheimer's, and the probate proceeding, she has to be listed as a person under disability, and the court will appoint a guardian ad litem for her. So the disability can be either physical or cognitive or mental, and it has to be shown. And generally the courts look for any type of disability. They're not, it doesn't have to be a major disability.
We actually have another New York question. In the case of a married couple in New York with adult children, which is better, a trust or a will, and why?
Well, again, the trust has the significant advantage of eliminating the need for probate. eliminating the process of going to the court system, filing the probate petition, hiring an attorney, paying the filing fees. You know, there are certain things that have to be filed at certain periods of time. For example, you have to file an inventory of assets. You have to file an affidavit of completion. And these things cannot be filed whenever you want. There are deadlines, there are timeframes to file them. So it kind of elongates the process of distributing the assets. I like the revocable trust. I recommend it to virtually all of my clients. I think it's a great vehicle. And many of my clients, for example, that are doing elder law planning, they'll do a revocable trust for the assets that they want to keep control over. And the assets that they want to protect are going to go into an irrevocable trust. And if you think of your typical client, they have savings, a house, and IRAs or 401ks. If they have their house in an irrevocable trust that they want to protect and some of their money there, some of their non-IRA savings there, and then they have non-IRA savings that they control in a revocable trust, then they have their IRA. Guess what? When they're dead, there's no probate. IRA goes to the named beneficiaries. Money's in a revocable trust, go to the named beneficiaries. Money's in the irrevocable trust, go to the named beneficiaries. And you could be passing an estate of millions of dollars without going through this process with the court system. So I'm a big believer in the use of trust.
Okay, thank you. Anne Marie, this might be one that you can address. Given that each state has different rules, what happens if you set up a trust in one state and then move to another?
Most of the time it's acceptable. We recommend when people come into us that bring us their existing documents and it's governed by a different state. One of the differences is in the powers that's granted to a fiduciary in the documents, the trustee or the personal representative. So we make sure that those fiduciary powers match the Florida statutes. And if they don't, we obviously just do an amendment to the trust or a codicil to the will, and we state that the jurisdiction has changed to the state of Florida and the powers are amended to read as follows. And then you're covered. You don't have to redo everything. And you really shouldn't redo everything. When you're amending your trust, you amend your trust or you amend and restate, because if you have funded your assets into the original trust, you do not have to refund your assets again if you amend or restate your trust. You don't want to get rid of a trust to make a change. The initial trust stays the way it is and valid. Okay. Yeah.
Okay, thank you. Would you need to retitle an asset in order to put them in a trust? For example, would you have to change the name on bank and brokerage accounts?
Yes.
Yes. Yeah, you have to. That's one of the biggest problems with people that create revocable trust or irrevocable trust. In order for the asset to be controlled by the trust, it must be titled in the name of the trust. So a bank account has to be in the name of the trust. Real estate needs to be titled in the name of the trust. So you have to fund the trust. I have clients that come in all the time for initial consultation. They'll bring this big leather-bound portfolio with them. They had a revocable trust done. And then I asked them, well, what's in the revocable trust? And they say, I don't know. I thought the lawyer took care of that. That's not the case. You have to fund the trust. The trust is an empty vessel unless there are assets in the name of the trust. So you could have a trust and it will control zero if you haven't transferred any assets to it.
We also, after everybody signs their trust here, we give them a checklist and go over a checklist on how they transfer and what they should transfer. And if, the problem that we see, Anthony, I'm sure you see it too, is that they're dealing with brokers who each brokerage house has completely different forms. So at times we help with the forms, but the grantor of the trust has to actually apply for those forms. We have no authority to ask for any of that. We can help on the other end, but you have to fund.
Yeah, we generally fund all the real estate.
Yes.
We're doing the deeds of the property to the trust.
We do that too.
Yeah.
Yeah.
But we're not doing the moving bank accounts unless the client asks us to do that.
Mm-hmm.
In fact, our correspondence with the client says that you will arrange to transfer any assets to the trust.
Thank you. Another one here, can a trust help to protect assets when applying for Medicaid?
Yes. The trust that normally is used is an irrevocable Medicaid asset protection trust. For a tax perspective, it's a defective grantor trust. So the creator of the trust is treated as the owner of the assets in the trust for tax purposes. It's a fantastic vehicle. I've been using it for 30 years. Basically, what you can do is you can transfer your house and your non-IRA savings to it. You can reserve the right to live in the house. You'll pay all your bills just like you're paying now. You'll get the STAR exemption. You'll get the personal residence exclusion if the house is sold. Nobody can sell or rent the house without your permission. You have the power to change the trustees. You have the power to change your mind as who the ultimate beneficiaries are going to be. However, you don't have control over the principal of the trust. Once the assets are transferred to the trust, you can say you want the income. Either you must get it mandatory, or you could do it at discretion of the trustee, but no principal invasion could be made for your benefit. Once 5 years have gone by, the assets in the trust are protected and they're no longer counted as available resources for purposes of Medicaid eligibility. You should understand that IRAs and 401ks are not available resources for purposes of Medicaid eligibility. They're not counted as an available resource. However, if you ever go on Medicaid, you must put the IRA or 401k in payout status, and you must take your minimum required distribution. Medicaid is the payer of last resort. So if you have an income source, you have to take it.
Thank you. Would a trust work if you have property abroad?
Well, that all depends on the country.
Yeah, exactly.
Because some countries don't recognize trust laws.
Right.
So that's going to vary from nation to nation, whether they recognize trust laws. And then the other question would be, okay, can you put my property in Portugal in my trust that I created in New York?
Yeah.
That all depends on the laws of Portugal,
Right.
whether they allow you to do that. So there's no way for us to answer that
Right.
question. Yeah.
Great. Okay. One of you mentioned earlier, there's a new power of attorney form, I believe. If a
Yes.
person currently has a POA, do they need to execute a new one, or will the old one still be effective?
Well, this is the new statutory short form power of attorney for New York. It's a durable power of attorney. If you have one in effect, you do not have to execute a new one. That old one is still considered valid. As I mentioned earlier, when the law goes into effect on June 13th, basically there's no longer a need to have a statutory gifts rider. All gifting powers are going to be spelled out in the modification section of the power of attorney. There are now new regulations and rules about financial institutions, individuals, banks being able to reject the power of attorney. They may be, if they do reject it, there may be sanctions and consequences to doing so. The other big change is that one of the elements is that in the power of attorney in New York is that the language that you used in your power of attorney when you're preparing it had to be identical to the power of attorney statute. So if the power of attorney statute had typos, misspellings in it, you had to do identical. Now, the new power of attorney form has to be substantially compliant with the new statute. So there are some changes that are going to be made. Another big change is that if you're physically unable to execute the power of attorney, now you can have somebody sign it on your behalf. Another significant change. That wasn't possible in the past. In recognition of persons with disabilities, now you can have somebody execute the power of attorney for you. Raises a little bit of questions about possible fraud, possible issues, that they do it voluntarily or not. You know, a lot of times with these documents, we have to see how things play out over time. The existing power of attorney form is very cumbersome, requires initialing, signing. It was very, very difficult for seniors or anybody with any form of physical disability to sign it. So it is really welcomed that they've changed the power of attorney form. But again, you still have to see how many of these issues play out when the power of attorneys are being signed and what happens in the next 2 to 3 years.
Yeah, we also have a difficult power of attorney form down here. It requires initialing. Some of the banks require certain things to be initialed. Some of the banks require other things to be initialed. Some of the statute requires initialing. We make everybody initial everything because we don't know where they're going or what a bank's legal department in North Carolina is going to say about a Florida power of attorney. So we're a little concerned about that. We though also can have someone execute it with an X if you have the right notary acknowledgement with you, excuse me, in the document, and the notary is present. So there's a lot. Anthony's 100% right. This is circumstantial because you certainly don't want to have somebody come back and say it was undue influence or total incapacity or anything like that. So you have to have a relationship with the person who's preparing the document.
No question about that. No question. And you know, you always have to meet that person.
Yes.
Right? And you know, if you're an attorney and you're signing, you're executing a power of attorney for somebody, my theory is always whoever's signing the document,
Yeah.
that's my client.
Exactly.
Not the agent. It's the person signing the document. That's my client.
Yes. Yeah.
Great, thank you. Next one, can assets such as real estate be titled in an LLC and then made part of an individual's estate?
Yes. Yeah, sure. You if you own an interest, a percentage of the LLC, and that percentage you can convey to your revocable trust or irrevocable trust, or if you have a will, you can then dispose of that under the terms of the will. You could say, I give and bequeath my shares of such and such LLC to these individuals, and you do the same thing in a trust. In the trust, though, you would actually convey the LLC interest to the trust. So the trust would own your shares of the LLC, and when you die, that would be outside of the probate process.
Right.
Again, avoiding probate is very valuable in my mind. I mean, New York, the probate process is not onerous, but again, it takes 9 months to a year. And depending on what county you reside, it could be very difficult. I mean, if you're in Bronx County, New York County, Queens, Brooklyn, there are millions of people that live there. You know, it could take a very long time to go through probate. And if you have to do an accounting, to get the accounting filed, to get the accounting approved. So anytime you can avoid the court being involved, it really does save a lot of money, time and effort, and a lot of headaches for everybody.
Yeah, I agree 100% with Anthony. The only other thing is when you're dealing with an LLC, we always say, talk to your CPA and tell them what you're doing also, because they need to coordinate with the CPA and the lawyer at that point if they have an LLC interest or a corporate interest.
Right.
That's what we recommend.
Yeah, because if you're giving it to an irrevocable trust, you may be making a taxable gift.
Exactly.
And there's always basis issues. What is the cost basis that you have in the LLC?
Yeah.
But if you're creating a revocable trust, or it's going to be controlled by your will, there really is no cost basis issue, because the assets when you die will be includable in your taxable estate, and your children, your heirs, will get the property at their fair market value on date of death. They're going to get a step up in basis. So that's one of another advantage of assets, you know, being in a trust when you die. If I bought a house and I paid $500,000 for it, and I spent $100,000 on it in capital improvements, and now I give that house to my children outright, I make a quit claim deed. Well, my children are going to get the house at my cost basis, $600,000. So if the house is worth $1 million or $2 million, when I die, they're going to pay capital gains. However, if the house is in my revocable trust or my Medicaid asset protection trust, when I die, that house is going to come back into my taxable estate, and it's going to be includable in my estate at its fair market value on date of death. My children are going to get a step up in their basis. Their cost basis is going to be the fair market value on date of death. So when they go to sell it, they're not going to pay capital gains tax unless they sell it for more.
Yeah. And that's true in Florida too. Yeah. So.
Do you need to be a U.S. citizen or a resident to be able to set up a living trust in New York?
All you have to do is be a resident to be here. Yeah. I mean, obviously, there are tax rules that apply to individuals that are not citizens. You know, there are certain tax issues that apply, but there's no, preliminary requirement to setting up a revocable trust. If you're here, you can set up a revocable trust. The same with Medicaid in New York. People don't realize it. In New York, there is no durational residency requirement to get Medicaid in New York. I have clients that have literally been down in Florida for 20 years. They retired when they're 65, they're now 85, and now they're getting older, frailer. They want to be closer to their children. So they move back to Westchester County and they apply for Medicaid here. There's no durational residency. All they have to do is be here physically with the intent to remain, and they can get Medicaid.
Thank you. We do have a few more questions in the chat, and we'll share them with Anthony and Anne Marie and see if we can get some answers for some of these, but we are pretty much running out of time. It's 12:59, I think. So if there are any final remarks from any of you?
No, just wanted to say thank you for giving us the opportunity to help here. So thank you. Appreciate it.
Same here. Thank you very much. What I would say in closing to everybody, it's very important to do planning. You know, right now with COVID and all these other issues and the stresses we're dealing with, you really want to have that peace of mind that you have all your important documents in place. And even if you haven't done a will, I mean, it's a great time to think about doing it, or a trust, but more importantly, make sure you have the healthcare proxy. Make sure you have the power of attorney. You know, if you're a lawyer, you can actually appoint somebody who's a lawyer to be able to manage your practice in New York. There is a special power of attorney that can be done where a lawyer who is in solo practice, small practice, can appoint another lawyer to be able to manage their affairs if something happens to you. You know, I have clients and lawyers that have been sick for months. You know, they get COVID, they spend 30 days in the hospital, then another 30, 40 days recuperating, and there's nobody around to manage their practice. And you really don't want that happening.
Just plan however you want to. Yeah.
Okay.
Great. Well,
Yeah.
thank you everyone so much.
Thank you very much. Thank you.
Thank
Really
you.
appreciate it.
Bye-bye.
Bye.
Thank you.